Please be seated. We're here for oral argument in case number 1CA CV18 0079, RUBEN versus the Arizona Medical Board. And these proceedings are being audio and video recorded. So I would ask the counsel, please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. The appellant's counsel is advised that it's your responsibility to watch your clock if you want to reserve any portion of your time for rebuttal. We have read the briefs. We've discussed this case in conference this morning. And counsel, you may proceed.
Thank you. Your Honor, Robert Wolken, on behalf of David RUBEN, Dr. David RUBEN, in this case versus the Medical Board. From my perspective, this case began in 2009. I had the at the request of Dr. RUBEN, I represented him in a matter before the board at that time, and we negotiated a resolution of that claim, and that claim was resolved by consent agreement. Part and parcel of the consent agreement, and the reason that we agreed to enter into that agreement in 2009 was that the wording was put forth in the agreement by the state Attorney General's office. Said admissions by respondent are not intended to be made for any other use, such as in the context of another state or federal government regulatory action proceeding, civil or criminal court proceedings in the state of Arizona, or any other state or federal court. Unfortunately, the federal government wasn't a party to that agreement, therefore the federal government didn't abide by those words, and they ended up bringing a different charge that is actually part and parcel of the proceedings before this court. Originally, there were 5 charges that were lodged against Dr. RUBEN.
In the current action or in the previous action?
In this action.
Okay, I just wanted to make sure because you started off by the 2009. There was also a 2010 action, correct?
Yeah, I didn't represent him in that one. Mr. Zlackett represented him in that one. That document also had the exact same wording. The problem was that we didn't know at that time that the state wasn't going to honor that wording, and that the government was going to, from time to time, bring all that back up and use it as a basis for inflicting additional punishment on Dr. RUBEN. Can we start there?
Let's assume, for the sake of my question, that you are correct, that it was inappropriate for them to bring another allegation of unprofessional behavior, unprofessional conduct, based on the finding by the federal government. Didn't make a difference in this case? I mean, they still had 8 patients that they determined he had engaged in unprofessional conduct, correct?
Yes. Like I said, there were actually 5 initial charges that were entered. 3 of them are really not relevant in my mind because they were either not punished by the administrative law judge's decision or by the board decision. There's only 2 that were left, and the 2 that were left are the 8 patients that we're talking about. And there you have the issues with regard to whether or not the administrative law judge appropriately used a substantial minority test in order to determine whether or not there was any unprofessional conduct, which the state then, through the board, basically just totally ignored, said we're not going to use that test, we're going to use some different test based on who knows what, but they certainly didn't hear any testimony or have any other evidence before them.
That's not a requirement that they take additional testimony. And doesn't our case law say that we defer to the board because of their expertise in making those determinations? Well,
the expertise, the board consists of doctors and lay people. Well, there's no lay. The lay people don't have any expertise.
Well, the doctors do, don't they?
Yeah, the doctors do, but it's the entire board that made the decision.
Okay.
And we're talking about whether or not the board has to. We're talking about the Administrative Procedure Act, really, and what's the function of the Administrative Procedure Act in relation to the board if the board can totally ignore it? That's why the statute was changed to require that they put a written justification for their changes. What the board is insisting in this case, and what Mr. Rain is, I think, going to stand up and tell you, is that it's perfectly okay for them, if they can look back in the record and find any basis upon which they want to justify their decision, that they can simply do that. Well, if that's the case, then why do we have the administrative law judge conduct the hearing? If they can do whatever they want, why not just have a hearing before the board?
So how do you think that the board's discretion to do whatever they want is limited?
How do I think it's limited? It's limited by the requirement that if they're going to change the administrative law judge decision, they have to put a written justification for doing so.
And
now it's even gotten more better than that, because the written justification has to go to the legislature so that everybody knows what's going on.
It's gotten more restrictive, but that doesn't have to do with the time frame that we're talking here. So let's talk about what was in place at that time. What was required here that the board failed to do to justify the discipline?
Well, here's the way I would describe it is...
Well, while you're looking for that, let me see if you agree with this. The ALJ issues a decision. The state objects to the decision and files a motion with the board outlining their objection. Are we on the same page? You agree with the...
Absolutely, I agree with you.
And then the board, they agree with the state on some of their stuff, they disagree with the state on others of their stuff, and they say, and for the reasons in the motion, we adopt it. Isn't that enough to indicate the board's decision under the old version of the statute?
I don't think so in this case, not at all.
Why?
Well,
what more do they need to say then? Oh, what the state has written out in their pleading is good, is correct.
Well, then what you're saying is that when the Attorney General told the board what the parameters are of their decision, they said that the rationale was that the board wanted to impose different discipline. So, I mean, we can talk about theory, we can talk about what really happened here. What really happened here is that in the beginning of this case, the Attorney General, different Attorney General than we'll be arguing at this juncture, but indicated what they thought ought to be the punishment imposed in this case. So they made an offer to settle the case based upon the punishment that they wanted to impose. And so we didn't agree to that. The reason I didn't agree to it is because I'd been stung prior by the Attorney General, putting things in their offers that they weren't going to uphold. So we decided not to take that offer. We went through. I didn't represent Dr. Rubin at the hearing, but there were 8 days of hearings and numerous witnesses, and lots of contention at the hearing. And the bottom line was that. I mean, it's the drasticness of all of this. The bottom line was that the administrative law judge found that there was no unprofessional conduct as to any of the patients, based upon all the same evidence that the board turns around, and with the standard of clear and convincing nonetheless, says we find clear and convincing evidence, just the opposite of what the
Mr. Wolkin,
administrative law judge found.
You don't like the fact the board reviewed the record and came to a different conclusion. But even under the heightened standard of the new statute, the board can still do that, right?
Yes, they can do it. The question is,
So if they have that authority to do that, and they exercise their discretion in doing it, what's wrong? I mean, they're not bound by what the ALJ said. If that's what was to happen, they could create a statute to say, you have a hearing in front of the ALJ, and that's the end of it.
What's wrong is they didn't explain why they made their changes.
They adopted the position or the explanation of why they should from the Attorney General's position.
And that was the Attorney General's position at the time they made the settlement offer at the beginning of the case. Basically, they dictated what was going to happen in the case.
Well, what difference does that make?
Well, do we want to have a board that's a rubber stamp for what the Attorney General wants? Or do we want to have a board that makes an independent decision based upon all the findings and facts?
You are making a lot of assumptions there about the board. When we look at the ALJ, necessarily an ALJ is law trained, agreed?
I'm sorry, I didn't hear.
The ALJ is law trained. That's the training they receive before they become the administrative law
Yes.
judge. And as Judge McMurdy pointed out, on the board we have doctors and lay people, but we have doctors. So you would agree that professional and unprofessional conduct is judged by different standards because you have doctors looking at people in their profession as lawyers would be looking at people in the ALJ's profession. So when we look at finding different conclusions, they accepted the evidentiary rulings but rejected the conclusions.
Yeah, but you say they in a cavalier manner. They rejected, they accepted, and they rejected. And you're not talking about the whole board. The board experts may look at it differently than the board lay people, but they're all there. And
Was there a split vote on this issue?
I'm not privy to exactly what the vote was. I thought there was one dissent, but I don't recall who that would have been.
So all of the experts on the board agreed with the position outlined by the Attorney General in their objection to the ALJ requirement. Isn't that fair?
I don't know. I don't know the answer to that question. What I do know is that the Attorney General dictated what should happen in this case from the beginning. The Attorney General then went ahead and had evidence presented and facts and conclusions drawn that were against them, and they turned around and got the board to agree to what they wanted to do to begin with.
Hold on for a second. Hold on for a second, because that's not true. And we know it's not true because what did the Attorney General want as to be the discipline in this case?
I don't recall, but it was exactly
Revocation.
what was.
It was
Additionally, revocation. Well, there's new charges now, and based on that, there's going to be.
I don't have that information.
Yeah, okay, I understand.
But let's stop there as well. Okay. I'm a little put off by you saying that the board is the rubber stamp of the Attorney General's office, number one, because this is an independent body and they make their own decisions. This may be how the Attorney General started off with the offer to your client, and it may be what the board eventually adopted, but to kind of connote some sort of nefarious intent on the part of the board being the spokesperson of the Attorney General, I find off-putting.
No, I'm not saying the board was the spokesperson for the Attorney General. I'm saying the Attorney General is the spokesperson in this case.
Well, but
And the board just went along with it.
Well, but you said, as I understood it, that the board rubber stamped what the AG proposed. It seems that the board considered what was in the case and came to its independent determination, which in some parts was consistent with what the AG asked for and was inconsistent in other areas. I don't see what's improper about that.
It doesn't comport with the statute, is all I'm saying.
If
Their explanation is wanting. They have to explain why they're rejecting the ALJ's findings, and they didn't do it in this case.
Well, but if the Attorney General in its papers explains why the ALJ is wrong. If the board says, for the reasons stated in the Attorney General's pleadings,
There's no reason stated. They just made different findings. They uttered some opinions and said, here's the conclusion. They didn't explain why the minority rule, which the ALJ used, wasn't the proper rule.
I thought they cited throughout the pleadings to the record of the experts that had testified.
Well,
I mean, it wasn't the opinion of the Attorney General. I mean, their pleading is replete with reference citations to the record to support the arguments they were making to the board. And if they agreed, and if the board read the record and determined that the AG was correct in their assessment, then what more needs to be done?
well, if you're going to say that based upon a couple of snippets of testimony from one expert is going to do away with all of 8 days of testimony from two other experts that are not cited at all, and that the board should only follow the testimony of the experts that they prefer, then that's exactly what happened.
well, but isn't the board responsible for making credibility determinations, which is what happened here?
And I think the board's responsibility is to also set forth a justification for its findings. Didn't make such a justification is not in the record. It's an argument made by the Attorney General. It's not sufficient justification under the statute. You should look at the amendments to the statutes that show that they want absolutely specific justification. They want to hold to a much higher standard than has been held to in this case with regard to those justifications. They want those justifications to be presented to the legislature to make sure that the procedures are following the statutory requirements. They didn't do so in this case. What you ought to do, I believe,
we can't hold that they erred in this case by not following the statute, because the statute wasn't even in place when they.
Oh no, that statute was the statute.
Not the amended statute.
No. The amendment I'm just talking about is evidence that this court ought to consider as to what the original statute meant.
What are we? We're supposed to consider the heightened criteria
Yes.
that now exists to apply it to the board's action. When they did the action, it didn't exist.
No. I'm suggesting that you use the heightened criteria to find that the meaning of the prior statute it hasn't been changed. It's only been enhanced by the new statute. That they should be held to a standard that reasonably sets forth the justification for the changes, and they didn't do so in this case. The ALJ's decision is the decision that ought to be implemented in this case. I'd like to reserve my time.
All right, you may do so.
Thank you.
Good morning. May it please the Court, Assistant Attorney General Michael Rain on behalf of the Medical Board. The Board's final decision in this matter found that Dr. RUBEN had engaged in unsafe opioid prescribing practices for 8 separate patients. The Board's order detailed Dr. RUBEN's treatment of those patients, and it detailed the experts' written opinions and testimony regarding Dr. RUBEN's treatment, regarding the standard of care applicable to that treatment, and how Dr. RUBEN had fallen below that standard. And lastly, it also detailed the harm or potential harm that Dr. RUBEN's unsafe practices had caused to the patient and the public. And Dr. RUBEN has not argued, either in his written briefs or today, that any of those findings were not supported by substantial evidence. That's not his argument. What he's argued is it was just wrong for them to have rejected the administrative law judge's decision, and the basis seemingly being, at least in the briefs, that the clear and convincing evidence burden of proof was at play here.
Can we talk a little bit about the finding by the board that Dr. Rubin engaged in unprofessional conduct based on the determination by the federal government that he had engaged in unprofessional conduct, which was based on the conduct from the 2009 and 2010, I think it was from the 2010 consent agreement. The conduct is the same in both. The finding does not show unprofessional conduct.
The DEA's finding?
Right.
Well, what it finds, it cites to 21 U.S.C. 824A4, which is essentially whether having this DEA privilege is in the public interest. And there's several factors that they can consider under that federal code, and one of them is that the state had imposed discipline, but that's not the one they applied. They applied the finding that had to do with the public interest, and it sounds to me, at least, in the realm of safety and good practice. So I do think that they found unprofessional conduct. But I think another key point is that they, as I said, they weren't imposing reciprocal discipline at the DEA.
Oh, okay. I don't care.
No, I understand. What I mean
We're
to say
saying
is,
where Dr. Rubin engaged in unprofessional conduct, we know that he admitted to it back in 2010. His conduct was unprofessional. The state imposed a sanction, right?
yeah,
Suspended his writing privileges for a year.
yeah.
The federal government then takes the action, looks at his conduct, same conduct, and says it's unprofessional. And they imposed a year's suspension, right?
Yes.
Then you charge him, in this case, with unprofessional conduct based on the finding by the federal government, and you're going to impose you wanted to impose additional sanctions on him. For unprofessional conduct, which you'd already sanctioned him for, there's no allegation of new conduct as it relates to 2010. And you're right, the federal government then could take your sanction, if it was allowed to stand, could take your sanction and pose additional sanction. This could go on ad infinitum. As each government said, oh, a new finding by the other government, so we're going to impose additional sanction.
I would disagree that it can go on ad infinitum. Well, because it hasn't even gone on twice yet. So far, there's been one time that the state or the federal government has imposed reciprocal discipline. That was when the state found under the subsection P, if you've been sanctioned by the federal government, it's an act of unprofessional conduct. The ALJ agreed. That is a violation.
Okay, let's back up and make sure that I understand. 2009, 2010, consent agreement between the Attorney General's office and Dr. Rubin.
Yeah.
Releases him from any responsibility arising from the conduct involved in that case or both cases, correct?
I think there's some dispute as to that.
But didn't apply to the DEA. So the DEA takes the settlement agreement and says, here, we're going to suspend your privileges for a year. So we've got the consent agreement discipline, then we have the DEA, and now in this proceeding, we're getting disciplined because the DEA disciplined him. But that discipline was a direct result of the conduct in 2009 and 10, correct?
Correct.
How can that be?
Well,
why would anybody ever enter into a consent decree? If you can sanction me today, and then I get sanctioned by the federal government, then you can sanction me for the federal government, and then they can sanction me.
No, I understand. Well, and the language that counsel for Dr. Rubin referenced was that the admissions made in that document were solely for the basis of resolving the state's case. That's what the federal government ignored, that those admissions could not be used. It used the state's consent agreements not to impose reciprocal discipline, but as proof on the merits of its independent discipline under the federal code. So it wasn't reciprocal in the sense that they said, the state disciplined you, therefore we can. As you see that DEA order, it's quite extensive, and they also look beyond just the admissions, and they look at the treatment of the patients, and then they impose discipline on the merits of that case. which shows, I think, the fact that it's really just the order of proceedings that make this appear to be unfair at this current stage, where it hasn't gone back and forth.
No, hold on for a second. I think you're missing the point. The point is not that the federal government can't take action. No, I don't think that's in dispute. They're the federal government, a separate sovereign. They can do whatever they want.
Yeah.
The action is you punished him for conduct. I don't care if it was a consent decree or if it went through a full hearing. You punished him for conduct, right?
Yes, for the 2009, 2010.
Right. You punished him for unprofessional conduct. He goes over to the federal government and they punish him because they can do it. They're a separate sovereign. Then the issue comes back, if Dr. Rubin has engaged in no other unprofessional conduct, can you turn around and punish him again simply because this other sovereign punished him for conduct?
The state's position is yes. The conduct that was unprofessional under P is not his 2009, 2010 underlying conduct. It is literally just the fact that the DEA sanctioned him, and I believe that's the end of it. But as I was...
How is his conduct unprofessional? Okay. Conduct in the 09-10, unprofessional. He agrees.
Yeah.
Bingo to bango, we're done with that conduct. There is no additional conduct that justifies the DEA other than it being a different sovereign, correct?
Yes, they had other allegations that were unproven.
He can be sanctioned twice by the state based on an independent determination by a different sovereign.
Well, I think ultimately this starts to get into semantics, because there's no evidence in the record whatsoever that he received a sanction for this violation. The ALJ found he was in violation. The ALJ found that he had already been punished twice for the underlying conduct. The board accepted both of those findings. It accepted the finding he had already received punishment twice. And as we addressed in the brief quoting from the time when the board was reviewing the ALJ's decision, there wasn't a single mention of this violation deserving or meriting additional punishment, and the board's order acknowledges he's already been punished twice. So the idea that he's actually receiving new discipline is just not borne out by the record. It is a violation to have been sanctioned by the federal government, and that charge could not possibly have been brought until the federal government acted. Had the federal government brought its case on the merits first involving these 8 patients and sanctioned him, I don't think anyone would look at this case and say it's unfair now that the state second does its case on the merits. At that time, it would already have the federal government's sanction.
Of course, because you've got 2 sovereigns, and both sovereigns are entitled to extract their pound of flesh.
Yeah.
But the bottom line is, just because both sovereigns have now exercised their authority and sanctioned him, why does it's not more conduct? There's no more conduct.
No, I understand Your Honor's point. I certainly do. I think the board understood your point, and that's why they accepted the ALJ's finding of fact that he had already been sanctioned twice and didn't engage in any further discussion about, and what are we going to do with this subsection P violation. In the Holes case, it's cited for a different reason in the brief, but an interesting part of that is discussion of whether if one charge went away, what do we do with the discipline? And the discipline that was imposed in this case was very modest, tailored discipline. This was Dr. Rubin's 3rd time with this same type of misconduct in 5 years, and he got a practice restriction of a couple years. The board had asked for revocation. And I think under any any violation gives the board the right to revoke.
So just so I'm clear, let's stop there. So it doesn't matter if you allege 800 violations of different sections of code or 1. If 1 is proven, the board can impose discipline.
It can impose up to revocation under its authority. The board may revoke or suspend a license for acts of unprofessional conduct. It could be such a case where if you revoked someone for a nothing violation, that would rise to the level of being arbitrary and capricious. That's not, an issue in this case. So I'm not arguing that they should revoke for the minor violation, just that the authority for the discipline that they did impose is fully supported by the subsection Q unsafe practices violation.
So if the board had imposed additional punishment based on the DEA violation, which would be misconduct, would that be permissible if it's all based on the same conduct?
Hypothetically, I think yes. The ALJ had a finding that the board did reject after she had found that the statute had been violated by its terms, and she had found that he'd already been punished twice. She then concluded there are no grounds to discipline him. The board rejected that, and I think for good reason. It's a little bit inconsistent. The grounds to discipline him are that he's been found to engage in unprofessional conduct.
But
So
that's all taken.
the authority is there.
That's all been resolved and adjudicated. He committed misconduct in 08 or 09 and 10, whatever the years were. He entered into the consent agreement. He received his punishment. DEA, based on that conduct, DEA imposed its own sanctions. At that point, can the board impose additional punishment because the independent sovereign DEA found its own violation? That theoretically could go on forever.
Well, I think in theory it could, but you haven't even been cited by Dr. RUBEN a statute that would give the federal government now the authority to do that. There's nothing in the record to suggest this now long time elapsed that has happened. But in theory, that's the theoretical argument. There's nothing in the record to support they actually did impose punishment for the violation. But the violation would be the grounds for punishment should they have chosen to do it.
Well, wait a minute, you've lost me. DEA posed a year sanction, writing sanction,
Yes.
correct? All right, so that was punishment.
Yeah, I mean, the board's current case, the one on appeal now, there's nothing in the record to suggest they looked at that violation and said, and for this one, we're going to give you something additional or different.
And I don't speak for Judge Howe, but I thought his question was, hypothetically speaking, if you're looking at punishment for conduct, and then the separate sovereign, the DEA, imposes punishment for conduct, same conduct, could the board then file another charge and punish that doctor for unprofessional conduct based solely on the fact that on the conduct that was the subject to both sovereigns has been punished?
Yeah. And it could just be that you don't like my answer, but I understand. Here's a better answer, perhaps, which is to say that I think it would start bumping up against being arbitrary and capricious had they imposed additional
I think it's
discipline.
crossed right over that line.
Well, had it happened, Your Honor, but it hasn't.
Well, that's the issue. Is there anything in the record to indicate the board would have taken a different action had it not been alleged that way?
No, and there's evidence in the record that supports that it did not impose the discipline in the finding that it accepted that he had already been disciplined twice, and the complete lack of any discussion about this violation, coupled with the fact for the third violation of some very dangerous conduct, Dr. RUBEN having been given the chance at remediation, having already had a practice restriction, what he received was a 1 year longer practice restriction. There does not appear to be anything in the record that this issue moved the needle one way or the other to the board. And as I noted in that Holes case, the discipline that they did impose is fully sustainable under the subsection Q unsafe practice violation.
So your bottom line is that the board could find that this was additional misconduct, but that's as far as you're going. You don't want to venture into whether there could be additional punishment for that.
Well, I don't.
That's been appropriately before us.
Exactly. Certainly we don't want to hang our hat on that violation in this case. This case was about these 8 patients. Developments had happened. He had received this sanction. I think the statutes provided them the technical authority to have found a violation, and a violation supports discipline. But they didn't appear to have imposed it, And even if they had imposed a minor penalty, that a one step too far even to even impose a decree of censure, the existing discipline is so modest and so tailored toward those 8 patients' treatment that it can be affirmed, that you can affirm that discipline on that violation, even if you said, we don't like the subsection P violation. And you know, I hadn't anticipated this issue being as important as it is, but I want to give you any more time for questions on that, but otherwise I would like to address some of the other issues. Thank you. You know, one issue that Dr. Rubin ignores with the written justification is that it's accurate. We cited to you in the briefing the transcript from the board's consideration of the ALJ's decision. And the board was represented by independent counsel. And when the board member, Bain, made her motion to modify the ALJ's decision, she was advised by that attorney, you need to state a rationale on the record. It can be your own rationale, or you can adopt one of the parties' arguments. And another side note, Dr. Rubin made a motion to modify the ALJ's decision. So it's a little disingenuous to now come in and say, how can we be modifying these ALJ's decision? His motion just wasn't the one the board adopted. So what this board member, Ms. Bain, had, or board member Bain, I'm not sure if she's a professional or not, she adopted the state's rationale. So when the written justification is sent, and that's record item 221, it does exist, and it says the board modified it for the reasons set forth in the state's motion, what else would it have said? That was the reason that the motion was made. I think anything else would be a post hoc, board staff created rationale that wasn't literally what the board's rationale really was.
So let's just hypothetically talk. Post the adoption of the new requirements, do you think this would have been sufficient?
Well, they have this new requirement to send it to the legislature, so that didn't happen. But otherwise, when you look at the state's motion, and I think there was some discussion from your honors about this, each change was supported with citations to the record, except for those changes that involved there being a lack of evidence in the record. You know, you don't have a citation for that. So each fact, each modification was justified in the state's motion, not because they forecast this change in the statute, but just because it was a thoroughly drafted motion.
So I guess I'm used to thinking in a criminal context. You've got charges, there's punishment for each charge. And what you've explained to us and what I've been able to glean from the record is you can't stack violations. All the board has to do is find one, for whatever reason, unprofessional conduct event, and they are entitled to impose discipline. Not we can talk about proportionality of that discipline in relation to the conduct, but that's not what I'm saying. One violation equals discipline ability of the board.
Exactly. And perhaps this might help with the criminal context. I'm aware of cases where a jury might have or a judge might have decided punishment, but one of the charges goes away, and the court might ask itself, well, we don't know what they would have done without that part of the violation. It's not really the case in the board context. It is the jury. It imposes the punishment and finds the violation, and it's given the opportunity for rehearing and review where these issues are raised before it. Now, the rehearing and review motion, I brought it with me, but it's a little dense. It appears different than a lot of the other motions. It's very narrative. Either they raise this issue of this additional punishment for the DEA sanction, for example, or it would have been waived, having not raised it in rehearing or review. But had they raised it, and I believe they did, it's just a little unclear to the board. The board was presented with the problems, hypothetically, being generous to our side, of the DEA sanction. They still maintained their decision after rehearing. They were the decider. They were told, or should have been told, about this grievance with this DEA issue, and yet they maintained their discipline. So I don't think we have to wonder what would the board do without the P violation. And I think, just logically speaking, the P violation is a ticky-tack minor issue in this case involving these patients. I believe my time is up. So.
All right. Thank you very much, counsel. Mr. Wolkin, any rebuttal?
For what it's worth, let me just say this to your honors, that none of the violations that were alleged were made by patients. No patients were harmed, not by anything that Dr. Ruben's ever done or ever been accused of. But here we stand with this procedural morass, And as I sat there, it came to me that what the state's position is, what they're saying, is that it's only the admissions that they agreed they wouldn't use against him. It's not the conclusions based on those admissions that they would use against him. That's nonsense. That's sophistry. That's what they've been doing in this case. Mr. Rain stood up and he said to you 3 times he's been sanctioned for various dangerous behaviors. That's what he says to you. And he says that he already had discipline, a substantially dangerous behavior, a pattern. All of those things are based on the 2009 and 2010 imposition of sanctions. Now,
the board could consider that in determining what's an appropriate sanction in this case, though, right?
The board can consider that?
Sure. The board can consider what conduct he had engaged in 2009 and 2010 in determining what's an appropriate sanction for a violation in this case.
No, they said that they weren't going to, but...
No, they said,
they said in a regulatory proceeding they weren't going to use this against him. They weren't going to use the prior sanctions.
They can consider his conduct, correct?
Again, I don't think that's realistic. I don't think that's what happened. I think what they're doing is they're trying to punish him for the 2009 and 10 sanctions time and time and time again. If you look at page 13 of my brief, I outline that there's only three bases for sanctions: 7 patients, 1 patient, and the DEA actions. That's what they did, and that's what they shouldn't have done in this case. And they should be held by this court to place an accurate written justification for deviating from the administrative law judge's decision that there was no unprofessional conduct. They didn't do it. They just looked at it and came to a different conclusion.
All right. Thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your argument.